very much, Michaela. Hello, everyone. This is a smaller, more intimate group than I was expecting to talk to, so we'll deal with that and carry on. If I could very quickly begin today by acknowledging the traditional custodians of the land on which we meet and pay my respects to their elders past and present, and I extend that respect to Aboriginal and Torres Strait Islanders people who are here today. Thank you very much, Michaela, for inviting us along. My name is Chris. I'm a lawyer at a firm called Hall Wilcox in their corporate and commercial team. My day-to-day practice involves advising corporations and incorporated associations, primarily in terms of governance issues. Leaving that aside, I've also been a member of various incorporated associations through the years. I've been a member, I've been a secretary, and I'm currently the president of a little community organization. So I do have some experience of this from the coalface, as it were. Based on that experience, the secretaries are the hardest working group. I don't know if we've got any secretaries on the line, but if we do, they're, in my experience, some of the hardest working bunch. So hopefully that's earned me some brownie points with you. Our firm, in general, covers a number of different areas of law, includes a thriving pro bono practice, and it's on that basis that we've teamed up with Volunteering Queensland to deliver this short talk today. We've got about half an hour in which we're going to be talking about the recent changes to the Incorporated Associations Act. We're going to focus on the grievance procedure and how that works or doesn't work, and how it's supposed to work, but we'll also touch on the other changes that have come in briefly, because there are some interesting ones there, particularly for law process nerds like me. We will have some time for questions at the end. I would prefer it if those were questions about the changes, but if you want to know more about me, you're welcome to ask questions about that too. As we're going, if for some reason I drop out, I do have some slides which we'll throw up in a moment. If you can't see those, if you can't hear me, just let us know. If there are only the 5-6 of us here, then feel free to join in or drop something in the chat and we'll see that. If you have detailed questions, again, if we're a small number of people, bring them up as we go along, but otherwise leave them until the end. We'll cover them in the questions section. So, let's have a look at this. I'm going to share my screen so we can all see my slides, which I shall share with you now. I might ask Grace to give me a nod of the head if she can see those. Fantastic. Okay, let's continue. So, quick rundown of what we're going to cover today. We're going to cover why the changes are here, what the changes are, when they come in, and then we'll have some time at the end for questions. I always like to start these sort of talks with a quick explanation of why the changes are being made and the vague hope that that'll make people feel more positively disposed towards them. In this case, we're talking about amendments to the Incorporated Associations Act of Queensland. They're brought in by the Associations and Corporations and Other Legislation Amendment Act 2020. It's the first substantial piece of reform legislation for the Incorporated Associations Act since about 2007, so it is due for a look. The stated goals of this change were to modernise the Act and to deliver amendments to improve the internal government associations and reduce red tape. That's the blurb that I've got there is from the explanatory memorandum for this Act. How well that did, we'll find out. So that's in a brief nutshell why these changes are being made. What are the key changes that are there? There are a whole bunch of different changes throughout the Act. What are the key ones that we really care about? The internal grievance procedure, which is what we're going to be focusing on today. Management committee duties, duties for the management committee to be careful and diligent, prevent insolvent trading, not profiting from their positions, which brings that more into line with duties and obligations that are on directors of corporations. Where there's reduction of duplicate reporting, which is always fantastic to see. Some modernisation of the use of common seals. I don't know how many people still use seals, but that's changing. The ability to hold meetings using technology, which is always fantastic to see. Could have used that during the COVID period, but at least it's here now. And in many cases, will probably be reflective of what some organisations are already doing. Disclosure obligations in terms of remuneration, increased maximum penalties, the sort of stuff you get after years of an act not being updated. Before we get to the next slide, as a lawyer, my instinct is to give you tons of legislation and read it to you. Nobody's going to enjoy that. So I only have one slide of legislation. We're about to hit that. everything else, the Act is not enormous. You can find it as needed. And if you need to go back through the recording to find references, you can certainly do that, because this presentation is being recorded. So with that proviso, with that content warning, as it were, the trigger warning, this is my one slide of legislation. This is the grievance procedure section that is newly inserted into the Corporations Association Act. There are a number of things to look at in here that are useful to see. This also nicely demonstrates why I don't like putting slides of legislation up, because it's very small and very hard to read as part of this presentation. But I think this is an important one to look at. So taking it literally from the top, the Rules of Human Association may set out a grievance procedure. That's an important one to notice. For dealing with disputes between different people and entities, it can cover member of management committee, or member in the association itself. There are certain mandatory requirements, so your grievance procedure must include mediation, and it may provide for a person to decide the outcome of disputes, so what you would normally think of as an arbitration or an arbiter. You must allow members to appoint someone to act on their behalf. In applying the grievance procedure, each person must have an opportunity to be heard, so it can't be a kangaroo court. The mediator and anyone engaged to decide the outcome must be unbiased, so in practice a third party independent of all other parties. You can't, for example, if someone has a dispute with the chairman of your management committee, it can't be the chairman's wife who is acting as the mediator. If someone has initiated a grievance procedure, the association can't take disciplinary action against them until that procedure has been followed. And then the interesting one is subsection 6. If the rules of the association do not set out a grievance procedure, and you'll remember that this is a may section, so your rules may cover a grievance procedure. If you don't, and also if you have one but it's not consistent with these requirements that we've been talking about, then the rules of the association are taken to include the provisions of the model rules providing for a grievance procedure. So the model rules will, stick a pin in that, set out a example grievance procedure. If you don't have one of your own, you're going to be covered by that, or bound to that. And lastly, number 7, just to remove any doubt, you can't contract out, well, you can't make your way out of this process. Under the model rules, as you may know, there's a provision that says, look, if your rules do not cover something that these model rules do, unless you say otherwise, the model rules are taken to apply, so people can opt out of that. Not so here. Even if the rules of your association try to get out of this process, this still applies. So with that in mind, let's talk about this in slightly more detail. Some of these we've covered, and first I would like to talk about must versus may. As we saw a moment ago, this section says you may set out a grievance procedure. You do not have to, but if you do not, then you're going to be covered by the template process set out in the model rules. There are certain mandatory requirements that you must cover, and if you don't cover those, then again the model rules are going to apply. We've covered what those were. Must include mediation, must be able to appoint someone to act on someone's behalf, must be unbiased, etc., etc. We've covered then that if you don't provide for your own rules, the model rules apply. Anyone who's checked the model rules recently will know that they've recently been updated. They do not as yet contain a grievance procedure. We've been following up with OFT trying to find out what the status of this is, where is this thing at, and the most recent update that we have as of Monday, thanks very much to Grace, who's on this call, for sitting through the process of talking to Office of Fair Trading, is that they're working on it, and they are. There was a consultation process that ended, I believe, in mid-September, but it involves changing the regulations that go along with this act. They're not yet set on how they're going to do that. It is to come. What they have said, however, is that there is an example grievance procedure on their website. And there is, and this is the link that I've given you on the slides here. And so the message from them so far is, model rules changes are coming. They're not here yet. We don't have a time frame for when they're going to come here yet. But in the meantime, you can use this procedure. So, sorry, I've just managed to get quite a long way ahead of my notes here. So I'll just scroll down to there. We'll go look at that example grievance procedure in a moment, because it is, to be honest, fairly good, and it ticks off a lot of the boxes that we would expect to see in a grievance procedure, although there are some shortcomings, which we'll also discuss. I do just want to quickly flag that as a general principle of legislation should not adversely affect rights and liberties retrospectively. So normally you would not look to put in place an act now that punishes someone for something they did previously, and that makes sense. In this case, however, just in case you're in any doubt, the rules of your association are affected by these changes, even if they were in place before the changes were made. Very expressly, any rules that are already in place when these changes come in are affected by the changes here. It was considered justified, given that there's an intent to assure members of incorporated associations have access to a fair dispute resolution process. So, with that in mind, let's have a little look at what the example process that the government has put up is. I'm going to see if I can use the magic of technology to wave it in front of you. I shall once again ask for the help of Grace to nod if you can see that that's changed. Fantastic, it has. It's not an enormous document. It's one page of introduction and then one page of sample association grievance procedure. So it's not enormous, which is a good thing. It's easy to read and understand, but also not being enormously comprehensive, it does potentially mean that there are some gaps here. We'll talk about those in a moment. So what does this cover? It covers disputes with members, members of the committee or members in the association. So exactly the mandatory requirements that we had seen earlier. It expressly can be used by a member or a former member. That's an option available to you and something you might want to consider when drafting your own grievance procedure. Is it purely members, or is it someone who is no longer a member? And the dispute that's raised may well be their removal as a member. You start the process via notice in writing to the other disputed party. Very standard. You need some way to say, okay, our process has officially happened. But for this example, it's that you give notice in writing to the other party. The parties then have 15 business days to resolve their issue. That's them talking to each other, see if they can resolve it themselves. If they cannot, they then have, or either party to the dispute then has 10 business days to inform the association secretary that they've been unable to resolve the matter. At that point, a mediator is appointed, and the wording from this example is the management committee must ensure that the matter is referred to mediation. And then it stops there. So it doesn't really specify whose job it is to appoint the mediator or exactly who that mediator is to be. It purely says that it's the job of the management committee to ensure that that happens. Once the mediator is approved, they then are required to have mediation happen within 30 business days of the appointment. And if the mediation process does not resolve the dispute, at that point, you then take this to the course that it would normally go to for a dispute, which is it would be taken out to the Supreme Court. The Supreme Court was installed back when the the Incorporated Associations Act was first brought in. The Supreme Court was installed as the adjudicator on matters between association members because of its broad power to grant injunctive relief and to deter frivolous or vexatious claims, which they can just dismiss. The idea behind this new regime is that the Supreme Court's still there, right? If this process doesn't work, you still go off to the Supreme Court. But given the court process is expensive and lengthy, they want to put some mandatory process in place first with the hope that members will be able to resolve the matter in that way before needing to go off to the court. So the rationale underlying this, both associations and their members would benefit from formalized internal dispute resolution process prior to the initiation of court action. So that's what the example grievance procedure looks like. And to be honest, that's like the ones that we would usually use in our day-to-day practice. You would have some triggering mechanism, you'd want that in writing, that says a dispute has already happened. You have some set time frame for the parties to the dispute to work together first to see if they can resolve the issue, because if they can, excellent. But you make that a set time frame. You then move that off to some other form of dispute resolution, be that mediation, which is required here, or arbitration, or something else. Mediation being a mediator, an impartial party is appointed to help guide the discussion between the parties. The mediator isn't a judge, they do not make a decision, they help the parties come to an arrangement between themselves. Contrast that with arbitration, which would normally be someone set up, an arbitrator would be someone given the power to decide a dispute. And the parties would say, right, we're going to go to this arbitrator, we will abide by the decision that they reach. So you would have then some form of alternative dispute resolution mechanism, mediation, arbitration, and again, some form of time frame on that. It's probably going to be a bigger time frame because you're dealing with a third party who will be busy. They'll have their own things that they got on. Who knows how long they'll take. And then at the end, if that does not work, a set time frame again, for which either party can then kick the matter off to take court action. So, with that in mind, this is what the quick graphic of the process under this example grievance procedure. You give your notice, 15 business days for the parties to try and do it themselves. You have a maximum of 10 business days to inform the secretary. There's then some random time for which a mediator is appointed. And that's a key problem with this particular example. Depending on how long it takes to appoint a mediator, that blows out the time frame for resolving the dispute. The mediator is then appointed. Again, there's 30 business days for mediation to be held. And if at the end of that, they still can't reach a resolution, you go off to court. This is not a quick process. As you've seen, if parties don't, particularly if the parties are not agreeing, you've got 15 business days, assuming you say to the very next day, say to the secretary, we've got a problem. The secretary could take, and the management committee could take however long to appoint a mediator, and then there's a further 30 business days on that for the mediator to hold the mediation. So it is not a quick process. That said, the timeframes have been built with the eye of making sure there's fairness for everyone, and too short a time frame obviously will disadvantage some parties. It's completely signed on costs. As a lawyer, I care about costs without wanting to disparage my profession too much. So normally we would expect to see some form of recognition of who is going to pay the price of this, because mediators, particularly third-party mediators and arbitrators, are not free. It may be that you can find one that'll whack for free. If you can, fantastic. But particularly when you're drafting your own, if you're looking to draft your own grievance procedure, you may want to think about who's covering the costs of this. It could be each party bears their own costs. It could be the association covers the costs. I wouldn't recommend that one, but you may wish to. It may be that the parties bear their own costs unless that's decided by the person making the decision on the dispute. There are a lot of different options that you could bear. I'd suggest as a starting point, parties bear their own costs is a pretty one to go with. Who appoints the mediator? We've spoken about that. The only requirement from this example is that the management committee appoint it. If you're looking at drafting your own, you may wish to be more specific about that and say exactly who will appoint them, or maybe tie down exactly who is going to be appointed as the mediator. And lastly, what happens if one party doesn't comply? So if one of the parties does not participate at all, can there be an adverse finding against them? Something to think about. What should you cover in your agreements policy? We've largely covered this, but these are some things you may wish to think about. Timeframes. Having seen disputes run, if you do not have locked-in timeframes, they will balloon out. So lock in a timeframe. And as we've mentioned earlier, there needs to be consideration given to how long that is. Too long and the process is too unwieldy, too short, and you risk it not being fair to the parties involved. Assign responsibilities. Who is required to do what? Costs. Who's covering the costs? Always important to consider that. Have notices required. So at each stage of your mediation, there needs to be notice, and we strongly recommend that be in writing. You don't want to get to the end of a 30 business day timeframe and then have a dispute about when was the notice starting the dispute actually given. It wants to be in writing, and you'd want to get a copy sent to the association. Is there any process for a formal investigation? It may be that before having the parties meet themselves or before appointing a mediator, you have some form of investigation by the association or by someone on the management committee. Is there any right to an appeal from this grievance procedure? The example we have up here doesn't have one, but it may be that once a decision, particularly if you're having the decision made by the association, you may want to cover some form of appeal process there. And of course, have you covered the mandatory requirements that are back in the Act? There are certain things that you must cover. They must be covered. So that was the extent of what I wanted to talk about in terms of the grievance procedure. And that I would then like to quickly bounce off some of the other changes that are in place that have come into place. We might do that quite quickly because I can see that we're starting to run low on time. We covered in grievance procedure. Management committee duties is a fantastic one because it places duties on the management committee that weren't there previously. They echo almost exactly the obligations that are on directors under the Corporations Act. They cover duty of care and diligence, duty of good faith, use of not misusing your position, not misusing information gained as part of your position on the management committee. There's a duty to prevent insolvent trading and an ability to rely on information or advice. Stepping through those very quickly, duty of care and due diligence is you must do what a reasonable person in the same position would do. There are penalties for breaking these. The penalty is 60 penalty units. A Queensland penalty unit currently is $143.75, something like that. So it's not pocket change if these duties are breached. I think it's about 8.2 grand, I think, working that out. So it is important that members of the management committee know they are subject to these duties. Example, unfortunately, given that these changes have only just come in, we don't have a whole lot of case law or examples practically of these being enforced. We do, however, have a lot of examples of the obligations on directors under the Corporations Act being applied. And as I said, the wording is almost exactly similar. In that case, so for a director's duty of care and due diligence, examples of where that has been breached is where they fail to observe management or other employees of the company. They failed to find out the true financial position of their entity. They failed to inform the rest of the board of developments that might have a negative impact. Things that a reasonable person would do. If you don't do them, potentially breaching that. Allowing companies to enter transactions for no or lack of benefit, failing to ensure you've got proper licenses, all the things you would expect someone to do. Duty of good faith, you must act in the best interests of the association and for a proper purpose. Again, breaching that, 60 penalty units for each breach. Must not misuse position. An officer of an incorporated association must not improperly use their position to gain a pecuniary benefit or material advantage, money, for themselves or for someone else, or to cause detriment to the association. So even if they do something that doesn't bring them personally a benefit, if it causes a loss to the association, they still run the risk of this. Again, breach, 60 penalty units. Use of information, if you misuse information that you get as an officer of an incorporated association, you improperly use that to gain a benefit or advantage for yourself or someone else, or to cause detriment, that's a breach. Duty to prevent insolvent trading. If you are on the management committee, you now have an obligation to make sure that the association does not trade while it is insolvent or while its liabilities exceed its assets. Won't mention that. Lastly, reliance on information. Expressly baked into the incorporated association. Now it's fantastic. You are allowed to rely on assertions of others, provided doing so is reasonable. So if you're reasonably comfortable that another officer of the association or an employee or a third-party professional advisor is giving you advice or information in an area of their expertise, in an area of their authority, you can rely on that information. Other amendments contained in the bill, how are we going? We're at 12:28. What I might do is mention a couple more of these, then we'll open the floor for any questions, and then I'll thank you all very much for your very kind time. Reduction of annual reporting, particularly if you are registered with the ACNC, the amount of reporting that you need to do has gone down. having common seal is now optional. In particular, fascinating point, there's now provision for verbal agreement where a transaction between two parties would be able to be authorized verbally. It can now be done verbally by incorporated associations. So that's fascinating, providing the person has the relevant authority. And it also provides that incorporated associations can execute documents without a seal if the document is signed by a member of the management committee and countersigned by the secretary, another member of the management committee, or a person expressly authorized to do so. So that'll help with process. Holding meetings via technology, fantastic. Both management committee meetings and member meetings can be held by technology. The example given is teleconferencing. It is subject to requirements. The technology must allow members to be heard and take part in discussions as they happen. So a one-way broadcast, like a webinar, not going to work. You need people to be able to ask questions and take part in discussions. We did this for my association recently. We did it via Zoom. Very thankfully, we only had 3 people Zooming in, so that was able to work out. If you have a large organization with multiple members, that's going to be quite difficult. There are special software setups that will do it, but often they cost money. Maximum penalties have gone up. Don't breach the act. I think that's everything that I really wanted to cover. When are these changes coming in? Most of them have happened already. As we said, the internal grievance procedure and the model rules, we haven't seen that yet. So that's still coming. The other thing that's still coming is disclosure of mediation. Remuneration. There will be an obligation to disclose remuneration at the AGM, but exactly what is to be disclosed is going to be set out in regulations, and we haven't seen those as yet. My marketing team kill me if I don't have this slide in there. It's a little bit about Hall and Wilcox. If you want to have a look at that, you can, because I think these slides will be available. That's everything I wanted to cover. I apologize for it being quite quick. Are there any questions that anyone would like to ask at this point? It's absolutely okay if not. Ideally, it would be about the changes that have come in and grievance procedures. It can be about me. I'm a Leo. I like long walks on the beach. But otherwise, I will thank you all very much for your rapt attention and hand back over to Michaela.
I don't know. I wanted to hear more about the long walks on the beach.
I very nearly started talking about my favorite legal case, I'll be honest with you, because my second favorite legal case touches on this. It was a fantastic legal case where a lady who was working in a bowls club, she didn't realize this. She'd been made a director without her knowledge. The bowls club traded while insolvent. It was a question of whether she was liable or not. I thought if we had time, we'd cover that. We don't have time.
Okay. Wow, that's very interesting. Those legal cases can be very interesting sometimes that you study after the piece. All right, beautiful. Thank you so much for everything today. Massive thank you to Hall Wilcox and Chris Wright for this presentation. Thank you. And thanks to everybody for coming. We might say goodbye there. No further questions? No? You finished your lunch, Rachel? Good. All right. Anything else for anyone else? No. All right. Well, you guys have a great